So, thank you for having me here tonight to discuss some of the international legal issues arising from the conflict in Gaza. And tonight I want to focus specifically on one aspect, the increasing role that corporations play in sustaining armed conflict, drawing in particular on Francesca Albanese's recent report From the Economy of Occupation to the Economy of Genocide. Now, I should start by noting that this is not a particularly new topic. Corporations and private commercial actors have long been involved in armed conflict, from profiting from the chaos caused by the conflict to providing material necessary for the execution of the military objectives of the parties involved. If you look at one of the earliest documents, the Laws of Armed Conflict, the 1863 Lieber Code that was adopted during the American Civil War, you can see that Article 50 makes reference to citizens who accompany the army for whatever purpose, such as reporters of journals, contractors or sutlers. Sutlers being civilian merchants who sold provisions to the army when they were in the field. And not to mention that there has been a long history of sovereign states engaging armies for hire or mercenaries to assist them in fighting their wars. And likewise, the role of private paid actors has been the focus of renewed attention. Most recently with the Russian use of the Wagner Group in Ukraine and also in Africa, but also, most kind of, sorry, my brain stopped working for 1 second, the widespread use of private military and security contractors in Iraq and Afghanistan surrounding American involvement in those areas. So this is not new territory to query the role of the private commercial actor who profits from the chaos of armed conflict, and to question quite rightly whether international law could play a better or more expansive role in regulating commercial actors. And there have been steps to do so under Additional Protocol 1, adopted in 1977, and also under the Mercenaries Convention. There is an outright prohibition on the use of mercenaries in armed conflict. And following on from the widespread use of private military and security contractors in the early 2000s, states adopted the non-binding but nonetheless influential document known as the Montreux Document on pertinent international legal obligations and good practices for states related to operations of private military and security companies during armed conflict, which itself dealt with basically outlining the rules that states should follow if they decide to contract security services. And then on top of that, we have the International Code of Conduct for Private Security Providers, which itself is a manual of instruction for the military companies themselves, outlining their pertinent international law obligations. So there is international law on this issue, but where there's a gap in the law, both internationally and to some extent domestically, is when you have situations of corporate involvement in armed conflict, where it doesn't get to the level of direct participation. So international law is very good at regulating what happens when members outside the armed forces take direct part in hostilities, but only when that direct part in hostilities has kind of causal proximity. I say very good, reasonably good. So the law of armed conflict, otherwise known as international humanitarian law, does contain rules that say if someone who is not authorised to take part in the hostilities, they're known as being, as directly participating in hostilities, and they will lose their immunity from targeting for as long as they're taking direct part. So if you are taking direct part in the hostilities, i.e. picking up a weapon, firing it at someone, consequences apply. You can be directly targeted, you might lose your status as to whether you're treated as a prisoner of war. If you commit breaches of the law of armed conflict, you can be treated as tried for war crimes and so on. But international humanitarian law has little to say about corporate involvement in armed conflict when it's not so direct. So direct participation is largely about the causal proximity to the eventual harm. Fire the weapon, launch the missile, plant the landmine, someone is injured or killed, you're considered to be directly participating because there is that causal link. But step back 1 degree, so manufacture the missile, construct the parts of the weapon, and international humanitarian law doesn't necessarily consider that participation to be sufficiently causally linked. It's just that 1 degree too remote, even though there is clearly that clear connection. So a weapons manufacturing plant would be absolutely legitimately targetable, but IHL would treat the people who work in the plant as civilians and therefore immune from targeting. And even more remote than that, even further removed from the law of armed conflict, is when corporations take advantage of and even support an armed conflict for financial benefit. There is no IHL rule that prohibits war profiteering, again, unless you get to that level of DPH. And I wanted to set the background for this because tonight I want to go through and do a close read of Francesca Albanese's recent report, which just came out in July of this year, on the economy of genocide. Now, I'm a lawyer, so this thing's going to be riddled with disclaimers, and the first disclaimer from the international law side of things is under international law, armed conflict and genocide are not coterminous. You do not need to have an armed conflict taking place as a precursor in order to prove an act of genocide. Legally, you don't need to have one to have the other. But as we have seen in Israel and the occupied territories, there is an armed conflict taking place, and we are seeing acts of, again, and I have to use as a lawyer the disclaimer, alleged genocide taking place that's been facilitated by the outbreak of hostilities following the October 7 attacks. So with those disclaimers out of the way, I want to look a little bit into detail into Francesca Albanese's report to analyse the key findings and the recommendations. Because the core of her report is basically tracking the metamorphosis, or perhaps the continuation, of Israel's war economy from one of occupation to one of genocide. And she does this initially by exploring how historically Israel has exploited Palestinian labour and resources, both through the use of Palestinian land for Israeli enterprises and then through the positioning of the Palestinian people as a captive market for Israeli commerce. So as Israel dispossesses Palestinian populations and then sells that dispossession back to them through things like monopolies on water and electricity in the occupied territories. And so in her report, she examines how this long-standing system of dispossession and exploitation actually set the groundwork for the crimes against humanity and genocidal acts that took place in Gaza following the October 7 attacks. And the report highlights that Israel had intentionally created Palestinian dependency on its infrastructure for essential resources, such as water, such as electricity and fuel, such that the subsequent cutting off of these supplies goes beyond just a military tactic and moves very, very quickly into the legal definition of Article 2 of the Genocide Convention, that one of those criteria for the commission of an act of genocide is deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. So Albanese makes the case that it was and is the deep connection between the infrastructure of the occupied territories and of Israeli control of such infrastructure that made the post-October 7 atrocities so quick to implement, that it was essentially very, very easy to repurpose infrastructure of occupation into a weapon of war and as a tool to violate international law. And Albanese in particular makes the case that the situation in Israel is one that forces us to think more broadly about corporate involvement in armed conflict. So to contextualise, if you think about it this way, a weapons manufacturer like a Lockheed Martin or a Thales can theoretically argue that their very existence is prima facie compliant with international law. Sure, we manufacture weapons, but we don't manufacture weapons that intentionally violate international law. So we're not manufacturing chemical weapons or biological weapons that are clearly banned under international law. And we don't encourage, assuming this is what they're saying, we don't encourage states to violate international law with our weapons. So therefore, once the weapon is sold to the state, their connection to what the weapon is being used for is severed. So it's not on Lockheed Martin if a state ends up using its F-35 fighter to intentionally bomb civilian infrastructure. So complicity lies with the state that carries on that act and not the manufacturer that provides the means to carry out such an attack. You know, it's the age-old cliche that guns don't kill people, people kill people. And this kind of reasoning underpins current international law weapons reviews, as outlined in Additional Protocol 1, that a weapon can only be prohibited if by its very nature it's a violation of international law, if by its nature it's going to cause superfluous injury or unnecessary suffering or result in indiscriminate or disproportionate damage when deployed. So that's why you see weapons like chemical weapons and biological weapons being banned, because by their very nature they can't be deployed in a discriminate manner. But as Albanese quite rightly points out, such disclaimers notwithstanding, the situation of corporate involvement in any situation where there is an armed conflict Sudan, Myanmar, Ukraine and Gaza, it can't be assessed in a vacuum. That the long-established and well-documented systematic oppression and restrictions placed on the occupied Palestinian territories and the well-established legal principles outlined first in the advisory opinion on the wall back in 2008 and then the newer advisory opinion on third states in the occupied Palestinian territories make it impossible for any corporation to engage in any kind of dismissal of causation and proximity to acts taking place in the OPT. That any corporation that sells land moving equipment like tractors or earth movers to the Israeli government must know that there is a very high likelihood that they're going to be used for the demolition of houses in the West Bank to support illegal settlements. So what Albanese is arguing for is a broader scope of what constitutes complicity and a greater understanding and appreciation of the heightened human rights due diligence that needs to be imposed on a wider range of corporate actors. So to delve just into a tiny little bit of the more specific detail, the report presents a detailed and extensive mapping of corporate involvement. She categorises named companies by their respective sectors and then goes through and details the specific allegations against them. And it's a very depressing and sobering read. So she looks at things like technology and surveillance and reports on the deep entanglement of US technology giants like Microsoft, Google and Amazon, with the Israeli government, specifically with their military and surveillance apparatus under their Project Nimbus, which is a system that's basically state surveillance and military targeting of the Palestinian population. And she also calls out Palantir Technologies for providing real-time battlefield AI systems and predictive policing tools for Israel. Despite known civilian harm. She looks at arms and heavy machinery. I mean, obviously the provision of arms, it's very clear what they're going to be used for, but in particular she calls out the heavy machinery from companies like Caterpillar and Hyundai and Volvo, which have been responsible for shipping heavy earth-moving equipment to Israel. And in this respect, she talks about the fact that it is impossible not to look at this in the context of the systematic bulldozing of Palestinian homes, Palestinian infrastructure and Palestinian farmland. And so that this equipment, even though it can be categorised as civilian, has become a militarised tool of destruction. And she also lists numerous arms manufacturers like Lockheed Martin, Leonardo and Elbit Systems, stating that their weaponry has been used in genocide in Gaza. And then she also looks at the financial and investment institutions, that basically global financial actors are central enablers of the settler colonial project. That major insurers and investors like Allianz and AXA are named for their extensive investments in companies linked to the occupation, while asset managers like BlackRock and Vanguard are cited for their significant stakes in implicated companies. So in framing her support, Albanese looks beyond just the law of armed conflict and specifically centres her study on the UN Guiding Principles on Business and Human Rights as its normative guide. Now, obviously, the guiding principles are not law. They're non-binding. But nonetheless, she points to it as being demonstrative of the environment in which these companies must be made aware of and in which they are operating. That companies operating in conflict-afflicted contexts have a heightened obligation to conduct human rights due diligence to identify, prevent and mitigate risks of their activities contributing to human rights abuses. And this framework places a responsibility on corporations not just to avoid directly causing harm, but to prevent their activities from being directly linked with or contributing to adverse human rights impacts. But Albanese goes one step further and says that it's not just human rights law that's at play here. She actually says that there is precedent for international criminal law, specifically the doctrine of joint criminal enterprise, to come into play, because she says that corporate involvement is not a passive act, but it's active collaboration. So in this framework, the acts of a single actor, such as a corporation supplying a piece of equipment, contribute to a larger system of international crimes. And this legal interpretation positions corporations as active participants rather than mere bystanders. And to support this argument, the idea basically that you could consider corporations being involved in a joint criminal exercise, she actually draws upon case law that came out in the immediate post-World War II era, specifically the prosecution of IG Farben, the German industrial conglomerate that was the largest industrial supporter of the Nazi regime, and which, in the aftermath of the war, was prosecuted for having manufactured and supplied the Zyklon B gas to Nazi death camps. And in that case, one of three against German industrialists, the other being Flick and Krupp, the Allied Control Council held that both individual executives and the corporate entity itself were accountable, and in the IG Farben case, resulted in the breakup of IG Farben and the dissolution of it as a company from the get-go. So the report concludes with a series of recommendations intended to dismantle this economy of genocide, as she calls it. And the most prominent of these is a call for a comprehensive two-way embargo on Israel. That it's not just about don't sell them arms, weaponry, the machinery that goes towards supporting the genocide. It's don't buy any of the fruits of that labour either. Don't buy any products from Israel that are directly implicated in what's going on. So this recommendation goes beyond the actions of countries that have only suspended arms sales, like Germany. It demands a ban on both arms exports to and imports from Israel. And it's framed not just as a policy choice, but as a legal and moral obligation under international law to prevent genocide. In addition, Albanese urges states and companies to promptly cease all business activities and terminate all relationships that contribute to human rights violations and international crimes. She calls for sanctions, for a full arms embargo, and the idea being that if you isolate Israel economically, that is the tool that is going to get them to stop. Now, unsurprisingly, as has been the case with anything that Francesca Albanese has done, it's been countered with significant criticism, challenging both her individual integrity and the substance of her findings. Critics, most notably the organisation UN Watch and the Israeli government, have launched a multi-pronged attack on Albanese's credibility. They basically accuse her of having a years-long pattern of virulent anti-Semitism and unrelenting anti-Israel bias, and of having a political agenda to isolate and delegitimise Israel. Now, they have pointed to evidence that, for example, in 2014, she tweeted that America is enslaved by the Jewish lobby, and to her alleged equating of the Holocaust with the Nakba, which is a form of equivalence that is widely recognised as Holocaust distortion. The report is also criticised for omitting the discussion of anti-Semitic violence and also for not condemning the attacks on Jews in Europe and the US following October the 7th. So those are the attacks upon her individually, which are, unsurprising against a UN special rapporteur. That tends to happen, but they've been particularly pointed against Francesca Albanese in this case. And likewise, there have been criticisms of the legal basis of her argument. In particular, the one I find quite amusing is that they criticise her reference to the UN guiding principles because they are not binding, but you kind of go, but she says that they're not binding, so I don't understand how that's a criticism. So, for example, one of the criticisms is that the Jerusalem Light Rail is criticised for serving settlements, but critics contend it provides equal services to both Jewish and Arab residents, which in their view disproves an apartheid narrative. Similarly, Israeli agribusiness demonises colonial exploiters for innovations like drip irrigation, but critics argue that these innovations provide broader benefits. So again, there is a lot of both sidesing that has happened in response. And the political response, in terms of the international political response at the state level, has likewise underscored a significant global divide. A coalition of UN human rights experts and civil society groups have expressed their unequivocal and unconditional denouncement of US sanctions against Albanese and full solidarity for Albanese, reaffirming that her work is essential to upholding international legal standards and accountability. And they argue that sanctioning a special rapporteur for fulfilling her mandate is a direct attack on the UN human rights system and a violation of the 1946 Convention on the Privileges and Immunities of the United Nations. This episode, the report, the sanctions, the polarised responses, has been characterised by Albanese herself as evidence of the UN being in a moment of existential crisis. The fact that a major world power can unilaterally sanction a UN expert for doing her job does suggest a significant challenge to the authority and the effectiveness of the UN system. When international institutions are unable to protect their own mechanisms and experts, it does, or at least can, signal a breakdown in the system's ability to enforce its own norms. But at the same time, I actually find as disheartening as the criticism is and as upsetting as all of this is, the fact that it has been so virulently attacked in some ways speaks to the power of international law and of the UN system, even though it is imperfect. As an international lawyer, my first lecture to my students is always the system has many, many flaws. But the thing that I've been telling my students, and the thing that I tell anyone who ever asks me about this, is if international law didn't matter, why is the attack so virulent? Why are such steps being taken to denounce the findings? Why sanction her? If she was just reporting stuff that had no meaning, that no one cared about, why sanction her? It's the same line that I've used when I was interviewed on radio about recognition of Palestinian statehood. One of the criticisms being, oh, it's empty, it doesn't mean anything. Again, you go, well, if it didn't mean anything, why did Netanyahu take so badly to it? Why was he so virulent in his condemnation of Australia for recognising Palestinian statehood? It means something. It's not everything, and certainly there is a meaninglessness to it in the sense of it's not immediately stopping what's happening in Gaza, but it is not without some force. So I'm going to wrap things up there just to kind of finish off on saying that the Economy of Genocide report has had a profound impact, irrespective of its lack of direct legal power, because it's, for the first time, I think, in certainly my study of international law, basically broadens the idea of corporate complicity in international discourse. And it really is forcing companies now to question their involvement beyond just this kind of, oh, well, we couldn't have known, or we're far enough removed that we don't know what's going on. And it's certainly been particularly important for galvanising public opinion and activist movements like the BDS movement. And I think is really an important kind of moment in time for us to really rethink what we mean by complicity under international law and our responsibilities as individuals and as collectivities to not condone, to not approve, to actually stand up and say that this is not okay. So I'm going to hand over now to Chris, who's going to talk a little bit about the role of the International Commission of Jurists in what's been happening lately.
Thanks, Emily, and thank you all for coming out on a cold Canberra night. It's amazing that so many people have braved the cold, but thank you very much for doing so. I haven't caught up with any news this afternoon or tonight, so I don't know whether the police search in northern Victoria for a person suspected of having killed 2 police officers has yet borne any fruit. But the situation in northern Victoria is worth reflecting on starting off tonight, my comments. The situation arose when police attempted to execute a court order. As a result of their attempt to execute a court order, 2 police officers were killed and 1 was seriously wounded. The police then started the process of law enforcement. They're conducting a search. It will presumably result in an arrest. There will be an investigation, a prosecution, a trial with the possibility of appeal, and if a person is found guilty and convicted, there will be punishment. The police exist as a standing force, and they're putting resources into this search. One police assistant commissioner I heard use the expression 450 resources. I assume that means 450 police officers involved in the search. The accused has rights. Even our fairly aggressive media always refers to the person being sought as the alleged killer. But so too are their duties on the police and on the public. The police have emphasised the public duties by saying that nobody should be harbouring the suspect and that it's a criminal offence to do so. The events that are occurring in northern Victoria are the product of centuries of development of law and of the legal system, including the enforcement of the legal system in this country. International law is, by definition, the law binding states and concerning states. That's where it had its origins some centuries ago. But it's extended beyond that. It started extending beyond that in the latter part of the 19th century, when the law of war, or international humanitarian law, had its origins. And international human rights law since then has taken it even further, affecting not just states but individuals, dealing with the responsibility of individuals, first in international law, then in armed conflicts generally, and then moving to the rights of individuals against states, but also as against each other. So it can no longer be said that it is simply the law of states, but it is the law that fundamentally affects the rights and responsibilities of individuals. And the law of complicity that Emily was just describing is an example of how this law is moving beyond simply dealing with states. My work domestically and internationally over the last 50 years has had its basis in international law, and it has depended on international law. In this country, that was a necessity. We don't have a domestic Bill of Rights in Australia, not in the Constitution and not in statute. So when I was Australian Human Rights Commissioner, my jurisdiction was defined by international treaties that Australia had ratified. It was not sourced in the Australian Constitution. As a human rights advocate in non-government organisations, I have argued on the basis of international law, the Universal Declaration of Human Rights, the two foundational covenants on civil and political rights and economic, social, cultural rights, and all the other international law that flowed from it. And as a UN investigator, I investigate compliance with international law. So for me, international law has been very much at the heart of what my work has been. And it's law that I have seen as being critically important to the well-being of individuals and the community of nations, because it does seek to govern and regulate and ensure proper relationships between states. I've had two experiences of involvement with United Nations Human Rights Commissions of Inquiry. The first dealt with Myanmar between 2017 and 2019, and the second since 2021 with Palestine and Israel. And the law that we apply is the law of the international system, international law. The work that we did with the Myanmar fact-finding mission in 2 years resulted in 7 reports totalling almost 900 pages. We found, after an examination of situations in different parts of Myanmar, Rakhine State, Kachin State, Karen State, Shan State, that war crimes and crimes against humanity had been committed by the Myanmar military over a period of years. We were established and appointed before the Rohingya clearance operation began in August 2017. So we were not mandated specifically in relation to that, but in relation to human rights violations violations of international humanitarian law generally. We dealt during the course of our investigations with the question of genocide. That was the second occasion on which I had had to deal with the issue of genocide. The first occasion was when I was Australian Human Rights Commissioner, and I was a commissioner on the inquiry into the separation of Indigenous children from their families. And as part of that investigation, that inquiry by the Australian Commission, we came to the conclusion that those policies of separation were genocidal. So that was the first time I dealt with this issue. The second time was in relation to the Rohingya experience of August-September 2017. Our inquiry didn't come to a conclusion on that matter at that time. We did come to conclusions about war crimes and crimes against humanity, but our examination of the issue in genocide was quite late in the fulfilment of our mandate. And we said that we ourselves could not come to a firm conclusion, but that the evidence was very strong. And we recommended that those who were responsible for the Rohingya operations be investigated and prosecuted for the crime of genocide, and their guilt or innocence should be decided by the International Criminal Court. That's happening. The International Criminal Court has taken up the reports that we produced and has been investigating the situation in Myanmar, specifically in relation to the Rohingya experience, but also more generally. And it has sought arrest warrants for the military leaders that we named in our report. We actually named those who we considered to be responsible. The International Court of Justice has also taken up the material in our reports. There is a case before the International Court of Justice, commenced by the Gambia and joined by many other states, under the Genocide Convention that is accusing the Myanmar military of the crime of genocide. In 2021, after the violence in Gaza of May that year, the United Nations Human Rights Council created a new commission of inquiry to deal with human rights and humanitarian law in Israel and Palestine. That inquiry has now been going for 4 years, and I was appointed to the inquiry soon after it was established. In the beginning, our reports looked both historically at past UN inquiries into the situation in Israel and Palestine, and examined in particular the question of the lawfulness or otherwise of the occupation. We came to the conclusion in our report to the General Assembly in October 2022 that the occupation was unlawful. We said that this was our conclusion as an official UN Commission of Inquiry. But we also indicated that in our view this required more authoritative examination by the top court in the international system, the International Court of Justice. We recommended to the General Assembly that a reference be made to the International Court of Justice for an advisory opinion on this subject. I've dealt with the UN for a long time, and I have very, very, very low expectations of anything ever coming out of it. I was surprised, therefore, that 6 weeks after we made this recommendation, the General Assembly actually made the referral to the International Court of Justice. And pleased when, in July last year, the International Court of Justice delivered its advisory opinion and endorsed the conclusions that our Commission of Inquiry had come to 18 months previously, that the occupation was unlawful. More about that in a few minutes. Since October 7, 2023, the focus of our work has shifted significantly. We had, just the week before that, developed a work program for the next 3 years. A week later, that was junked. What happened on 7 October 2023 was without precedent in the long history of this 100-year war, and what has happened since, even more without precedent. So the majority of our work since then has been focused very specifically on the events that have occurred on and after 7 October 2023 in southern Israel and in Gaza, with lesser attention being paid to the West Bank and to Israel itself. By the end of this year, during its 4 years of operation, our Commission will have produced 15 reports. 12 of those 15 reports deal principally with the events since 7 October 2023. In June last year, less than a year after the current tragedy commenced, we reported to the Human Rights Council in considerable detail 3 reports. One report looked specifically on what had happened on 7-8 October 2023 in southern Israel. Having gathered as much evidence that we could, in spite of the obstruction of the Israeli authorities, we came to the conclusion that the Hamas militants, the Palestinian Islamic Jihad militants, and others who joined those attacks had committed war crimes. That report is still the most comprehensive United Nations examination of what happened in southern Israel on those days. We also reported on that occasion, June last year, on events between 7 October and 31 December in Gaza. And we came to the conclusion that the Israeli security forces had committed war crimes and crimes against humanity in Gaza during that period. Since then, we have continued to examine aspects of the situation. Our approach, because we are an investigative body, our approach is to do our own investigations, form our own conclusions, apply the law to the facts as we have found them, and report our conclusions and recommendations. And we've approached that by looking at issue after issue relating to this current period of fighting. So we've examined what we found to be the Israeli forces' concerted destruction of the health sector in Gaza. We examined the destruction of education and cultural property, archaeological sites, churches, mosques, libraries, museums. We examined sexual and gender-based violence. We examined the impact on children. Our report to the General Assembly, which will be released in about a month, will deal with housing and land. We've taken it piece by piece. In each of those sectors, we looked, we found facts, we drew conclusions, and we applied the law. And in each case, we found war crimes and crimes against humanity. We have not yet delivered our opinion on the issue of genocide. Because of our methodology, taking all the pieces, putting the picture together, we felt that this was a matter that we needed to come to only after we had found comprehensively what the situation has been. Our report on genocide will be released 2 weeks from today, and it will be a long and detailed report that goes through the evidence as we have found it and applies the law and comes to its conclusions. Our focus in our report is very much on perpetrators of crimes. So individuals and state entities or quasi-state entities responsible for the perpetration of crimes. But we are also very much aware that although international law deals with the actions of states. Third states have obligations under international law too. By that I mean not the states that are parties to a particular conflict or a particular situation, but other states that are outside that situation. And so our concern has been to ask questions about what is the responsibility for the United Nations entities in themselves, but also other individual states, in addition to Israel and Palestine, which are the primary focus of our inquiries. What are the legal obligations of other states in this context? Other states have obligations under international law, even if they are not direct parties to a conflict or direct parties to a human rights situation. The 4 Geneva Conventions that deal with the law of war, or international humanitarian law, say in their Article 1, Common Article 1, that all state parties, and Australia is a state party, have obligations to respect and ensure respect in all circumstances. Respect means that they themselves should not violate the conventions, but ensure respect is an obligation to act to make sure that others observe the conventions as well. Ensure is an important word in this context. It's about obligation. Article 1 of the Genocide Convention says that state parties to the Genocide Convention undertake to prevent and to punish the crime of genocide. They undertake not just to avoid the commission of the crime of genocide, but also to prevent it and to punish it. Prevention comes in advance. It deals with situations where there is a risk of genocide, not just situations where genocide is occurring. So it's a prior obligation. And if there is any evidence that there is a risk of genocide, the obligation to prevent is triggered. The obligation to punish is an obligation that arises after the event. Punishment for the commission of a crime. There are both negative and positive obligations on states arising from these provisions in international law. The negative obligation, and this is from the commentary of the International Committee of the Red Cross, which is the primary interpreter of the Geneva Conventions. The negative obligation is that states may neither encourage nor aid or assist in violations of the conventions, that is, avoiding action. And the positive obligation? To take proactive steps to bring violations of the conventions to an end and to bring an erring party to a conflict back to an attitude of respect of the conventions, in particular by using their influence on that party. The ICRC suggests that this obligation is not limited to stopping ongoing violations, but includes an obligation to prevent violations when there is a foreseeable risk that they will be committed, and to prevent further violations in case they have already occurred. These are international obligations under treaty law, but they reflect international obligations under customary law. So all states essentially are bound by these, and they apply in relation to all states. This has been made very clear by the International Court of Justice. When the International Court of Justice gave its opinion on the reference from the General Assembly about the unlawfulness of the occupation, it dealt specifically about the obligations of third states. I should say, just by way of digression for a moment, one of the 15 judges on the International Court of Justice at the moment is Judge Hilary Charlesworth, who for many years was associated with the great Centre for Public and International Law at this university that is sponsoring the night. So Hilary Charlesworth was there, was one of the judges who decided this matter, and she will also be one of the judges who decide the case under the Genocide Convention that South Africa is bringing against Israel. Hilary Charlesworth added a declaration of her own to the general statement of the court in this advisory opinion. And in her own personal declaration, she referred to the right of peoples under unlawful occupation to resist the unlawful occupation. This was an addition to the court's decision, but her opinion as a judge. The right to resist exists in international law, but it is not cited very often in relation to the context of the Israel-Palestine conflict. The right to resist, I should add, and Judge Charlesworth emphasised this too, must be exercised in accordance with international law. So you can't go around and kill kids and claim that it's part of the right to resist. But the right to resist is there, and she recognised it. She wanted to specifically refer to it in her own additional statement. The court recognised the obligation of third states in quite some detail over a couple of paragraphs. It said that third states have obligations not to recognise any changes in the physical character or demographic composition, institutional structure or status of the territory occupied by Israel. Demographic composition is interesting. That's about movement of people in and expulsion of people out. The obligation to distinguish in their dealings with Israel between the territory of the State of Israel and the Palestinian territory occupied. The obligation to abstain from entering into economic or trade dealings with Israel concerning the occupied Palestinian territory, which may entrench its unlawful presence. The obligation to abstain in the establishment and maintenance of diplomatic missions in Israel from any recognition of its illegal presence. The obligation to take steps to prevent trade or investment relations that assist in the maintenance of the illegal situation. The obligation not to recognise as legal the situation arising from the unlawful presence. The obligation not to render aid or assistance in maintaining the situation. The obligation to ensure that any impediment resulting from the illegal presence of Israel to the exercise of the Palestinian people of its right to self-determination is brought to an end, and the obligation to ensure compliance by Israel with international humanitarian law as embodied in the Geneva Conventions. It's the point I mentioned before about the negative and positive obligations arising on all states under the Geneva Conventions. So these statements by the International Court of Justice are specific and strong. The ICJ is often accused of being very general, but there was nothing general in what it talked about with the obligations of third parties. I get concerned about much of the debate in Australia on this issue. We hear comments, we're a long way away from Israel and Palestine, we don't have any influence, what can we be expected to do? Those questions are valid questions. I don't dispute that for a minute. They're political questions, but, I'm a lawyer. The question is not, do we have any influence? The question is, what are our legal obligations? And whether we have influence or not, what are our legal obligations? I might be a lawyer, but I'm a naive lawyer. I would have expected that on the 25th of July 2024, the day after the International Court of Justice handed down its advisory opinion, the Australian government would have said, we need to look at this question. We will undertake a thorough review of all aspects of our relationship with the State of Israel to identify those aspects of the relationship that in any way aid or assist the continuation of the unlawful occupation of the Palestinian territory, as required by the International Court of Justice. That's the question. That's the legal question. That's the legal question for me. What aspects of this relationship aid and abet the maintenance of illegality. I don't know whether that was done because the government hasn't told us if it was, and they certainly haven't released the report, and it seems to me that the report should be released. And when Emily and I were at Parliament this afternoon, I suggested that if the government is not going to do this, well, maybe the Parliament should. Because it's a legal question. It's not a political question of influence, it's a legal question of obligation. And there are things that we can do as a result of this legal obligation, whether they have influence or not. The legal obligation is not to aid or assist in any way the continuation of the unlawful occupation, including unlawful settlement policies. That's it, simply said. And I can go further and say that because of the obligations under the Geneva Conventions and the Genocide Convention, we have obligations that are both positive and negative to ensure respect for the Geneva Conventions and to prevent or punish the crime of genocide. Noting, we don't have to make a finding that genocide has occurred to say that we have an obligation to prevent it occurring. And the International Court of Justice, when on the 26th of January 2024, it issued provisional orders in relation to Israel under the case brought by South Africa, the court issued provisional orders. It put us and all other states on notice then that there was a risk of genocide. It didn't find that there was genocide, nor has our commission. But the court has said, since the 26th of January 2024, there is a risk of genocide, and that triggers the obligation of all states to act to prevent. Australian government has said it will recognise the State of Palestine later this month. I think the date is the 22nd of September. That's good. It's not enough, but yeah, it's good. But there are other things that can be done under a process by which we review all aspects of the relationship and take action not to aid and abet, to ensure respect for the Geneva Convention, the Geneva Conventions, and to prevent or potentially punish the commission of the crime of genocide. Certainly, Australia should cease all trade with Israel in products, components and technology that are or could be put to military use, and end all trade with companies in Israel that develop or manufacture items that could be put to military use. That's ensuring respect to the Geneva Conventions. We could publicly affirm that we will enforce orders of the International Criminal Court, as we are required to do, including orders for the arrest of Netanyahu and for the arrest of Gallant, as the International Criminal Court has ordered. We could... I'm sorry, We could impose further personal sanctions against individuals in Israeli political and military leadership roles and who have had a role in the violence that's occurred since 7th of October. We could investigate, and where the evidence warrants it, prosecute Australian citizens who have served in the Israeli Defence Forces since 7 October 2023 for war crimes or crimes against humanity. Indeed, we have an obligation to do so. We could prevent the transfer of funds to the State of Israel or to any organisations in the State of Israel for the maintenance or establishment of illegal settlements. We should certainly withdraw tax deductibility from Australian organisations that raise money to send for the establishment of settlements or the maintenance of settlements. We could provide secondary sanctions on states that continue to provide weapons to the State of Israel. We say we've banned the sale of arms to the State of Israel, but there are other states that continue to provide weapons to the Israeli Defence Forces. We have an obligation under international law to seek to influence them not to do so. It's interesting to me that the United States has been pioneering this approach by applying punitive sanctions on India for buying oil from Russia. So it would appear that these kinds of secondary sanctions for the breaching of embargoes is now acceptable in the international system. There is much that we can do, but it's time that we reframed it to move away from the political question of what influence do we have to address the legal question of what are our obligations in this situation, because we have obligations. In the beginning, you'll be pleased to know I'm getting to the end. I'm sorry. In the beginning, I talked about the current situation in northern Victoria. It took centuries of the development of English common law, transposing it to Australia, having criminal law, having an enforcement mechanism through the police, having courts that are independent and impartial, having systems to enforce court orders and compel compliance with the law. That all took centuries. The international system needs exactly the same kind of provisions. And it's deeply depressing that after 80 years, it hasn't got them. But it's only 80 years. It may not take centuries. We've already got part of the way. I don't want to prejudge anybody, and I'm not making comments about any individuals, but as a general principle, a sovereign citizen killing cops is no different from the leader of a sovereign state killing kids. And we need, at the international level, the same kinds of provisions to apply. Crime is crime, violence is violence, criminality is criminality, and persons that are properly convicted should be held accountable for their actions. In Victoria, we are seeing a well-developed system of law, an independent, impartial system of courts that dispense judgment according to the law, a standing police force that enforces the law, processes of investigation and prosecution, court orders that are enforced. That's what we need at the international level. We have some of it. We have a good body of law now that has been developed with painful effort over the centuries, but especially over the last 80 years. We have standing international courts, the International Court of Justice, the International Criminal Court. We also have ad hoc tribunals like the ones that dealt with the Rwanda genocide, with former Yugoslavia. So we actually do have a pretty good court system. But we have poor implementation because states simply don't take their international legal obligations seriously enough. We have poor enforcement because enforcement is entirely dependent upon the dysfunctional Security Council or the political will of individual states or groups of states. And the future of international law has never been more uncertain. The international legal system is, in fact, in an existential crisis. It may cease to exist. It's entirely possible. It's never been under such serious attack in the 80 years since World War II. But what is the alternative to this imperfect system that still requires much, much more work? The alternative is that might is right. The alternative is the law of the jungle. The alternative is that we replace a rules-based international order with a fools-based international order. And regrettably, that's the direction in which we're moving. For all its imperfections, as someone who's dealt with international law now for decades, what strikes me more than anything is that international law and the international legal system is the only thing that stands between us and the abyss.